Hello, my name's Jill Pavley. I'm a law cost consultant and a member of TCP Richings, which is a firm that's been in existence for more than 50 years. What I want to do here today is to give you a little bit of an update on the civil justice reforms and perhaps more of the nuances of the changes within the rules that either have passed you by or because you're having to work so hard with your caseload, you haven't been able to catch up just yet. As I say, I have worked within the profession for in excess now of 20 years and I undertake work in all areas of legal costs, both for large commercial firms in inter-parties work through to the smaller sole practitioners and also with legal aid. So hopefully I'm able to bring some experience and that you will find the webinar here today of interest to you. What I think is one of the very most important things that has come through on the civil justice reforms is with regard to proportionality. We know that proportionality has always been there in the background and that people are having to be dealing with it normally at the conclusion of the litigation when we're dealing with costs on detailed assessment. Well, we have seen a change now since the introduction of the civil justice reforms on the 1st of April 2013. I now see proportionality as being an absolute integral part of the litigation from beginning to end. And indeed, we can see that the overriding objective has been altered, originally only having been referring to it being necessary for the courts to deal with cases justly. We have now seen that the civil procedural overriding objective has changed. What it is now saying is that these rules are a new procedural rule with the overriding objective of enabling the court to deal with the cases justly and at proportionate cost. So we can see that proportionality is now there very much at the forefront of the civil procedure rules in the overriding objective. Consequently, wherever you are thinking about dealing with cases and you are referring to the civil procedure rules, you will find that it is peppered with references back to the overriding objective. Therefore, there is being peppered with references back to proportionality. So now, please always have full regard as to how you are planning your case and what costs you're going to be incurred. Because undoubtedly, when we come forward, especially on multi-track cases, you're going to have to defend your position to the judge at the cost management or case management conferences when you are talking about your budgets. There has been a new rule with proportionality now applied. So the new test, as set out in the civil procedure rules, states costs are proportionate if and only if the costs incurred bear a reasonable relationship to, and then we have a list of factors, the sums in issue in the proceedings, the value of any non-monetary relief in issue in the proceedings, the complexity of the litigation, any additional work generated by the conduct of the paying party, and any wider factors involved in the proceedings such as reputation or public importance. So what we must now realise are those are the new factors we are going to have to consider when planning how we're going to run our litigation and the nature of the costs that are going to be incurred. So as I say, it is very important that you realise proportionality is with you all the time. So what are the practical effects of the new rules as we now see them? Well, we were hoping to have some guidance coming in with the civil procedure rules and their amendments as to what proportionality really now would mean and how we should be considering the same when planning our budgets. Unfortunately not. We are now having to sit back and wait for satellite litigation to evolve and thereafter case law to come forward before we can really give you any further advice as to how it's going to affect the litigation. And of course this is going to take a little while to come through the system, but nevertheless keep an eye on the case law that's going to be coming out so that we can get some more guidance. But obviously it is something that is evolving on a day-to-day basis. Cost management orders will mean in multi-track cases that proportionality is being dealt with very much at the forefront of the litigation, whilst your case is very much immature, i.e. after the filing of the defence. So you are now having to plan your case, deal with proportionality, which is very much in line with the matter of Jefferson versus the National Freight Carriers, the case law that came out quite some time ago. The Jackson reforms have now brought that to the fore. What problems do we see with regard to the new test of proportionality? Well, one thing that I am a little concerned about is it asks you to think about what it bears a reasonable relationship to. And I do believe that I was asking a number of people within a room what bears a reasonable relationship from one factor to another. We would all come up with separate reasons and ideas. And I do fear that this is going to be the case with the judges too. So maybe the rule isn't as tight as we would have hoped and may lead to some unusual decisions by the judges. When will the new test apply? Okay, the new test will apply only to proceedings issued after the 1st of April 2013 and costs that have been incurred after the 1st of April 2013. And this is pursuant to the Civil Procedure Amendment Number 2 Rule 2013. So please, can I ask you to bear in mind, when you're preparing your budgets, when you're preparing any statements of costs, or when we are preparing a bill of costs for detailed assessment, it may be necessary to split those budgets, statements or bills to work that was undertaken prior to the 1st of April 2013 as opposed to the work undertaken post April 2013. Different proportionality rules will apply, so I do ask that you take that into account.